episode of Surviving the Survivor, we bring you the best guests in all of true crime. Don't forget to subscribe and smash that like button. Here's your host, Emmy Award-winning broadcaster, Joel Waldman.
What's up, STS Nation, and welcome to another episode of Surviving the Survivor, the podcast that promises to bring you the very best guests in all of true crime, and also on our other channel, the best trials in true crime. And this is a pretty big court hearing this morning, which is why we are coming to you live. And our best guest today, of course, is Jeremy Mutz. Jeremy is a former prosecutor in Tallahassee and now has his own law firm in Chipley, Florida, in the Panhandle. Jeremy, thank you for joining us.
Thanks for having me. Good morning.
Appreciate it. And I just realized I think I had the start time, everyone, for 8:45. So apologies, but we're starting at 8:50 here, and I forgot to change that. I see Laura Waldy listening at work. Make sure you get no work done. I love that. J Squared would be the name of the band if Joel and Jeremy start one. J Squared. I love that. So Jeremy, I sent you, we got a little peek into what might be happening today. Among several things, Shanna Gardner, it looks like, filed a motion for bond. It sounds like she wants out of jail. What does that mean in layman's terms?
Well, in a first-degree murder case, a defendant is ordinarily not entitled to bond. Florida courts look at that under a very high standard. The facts of the case must present proof of guilt that is evident, or the presumption is great. So it's archaic language, but in simple terms, it has to mean that the prosecution must be able to show there's no question the defendant committed these particular crimes. And by their motion, they're trying to say, well, the court, even if they find that to be true, the court still has discretion to grant bond. And so they're asking the court to grant bond. They'll probably also argue that the evidence doesn't rise to that burden, because under Florida precedent, courts have found that in this question, the state actually has to bring more evidence than beyond a reasonable doubt in order to detain somebody from the time that they're arrested, indicted, then all the way to trial. And in most cases in Florida, that's what happens in a murder case. In a rare occasion, there might be bond. I think the Henry Segura case, the Thrash case in Tallahassee, Dr. Thrash was given bond, but it's very rare. So they're really just kind of throwing themselves at the discretion of the court to say, well, even if you find this evidence is there, my client will appear in court. You can require a very high amount of bond. She's not going to be a flat risk, and, please give us bond.
And she has the money. Her family is incredibly wealthy, from what I understand. They live out in Utah. But this is also potentially a death sentence case, death penalty case. So is that going to impede? What do you put the odds at percentage-wise of her actually getting bond today? It's got to be really low, right?
Maybe 1 in 10.
Yeah.
I'd say pretty low. And the death penalty is one part of it. Her great means to flee, probably more so than even the Adelsons had in terms of going to Vietnam and so forth. I think her parents had some sort of business, almost like Hobby Lobby, the equivalent of that in Utah. So they were pretty successful. So the court would look whether she's a flight risk and things like that. The fact that most of her ties are in another state, it's different if she was running a business locally and had all of her ties locally, you could say there's a little bit more assurance the court would have that she's not going to flee the area. But I think the court would look at it. Somebody has nothing to lose in this situation. They are facing the death penalty. And I think the state attorney, a very wise state attorney, Melissa Nelson, I think.
Wow. We've got a live courtroom shot already. You can see it right there. We're going to go to that as the minute proceedings start. True Lifestyles, by the way, what I love about our community is everyone helps each other out. And True Lifestyles is in Jacksonville and has been letting me know what time the hearings are starting and what's going on behind the scenes. She's here and she says she's not sure if Jose Baez is going to be in court today because Pat Karate is also here for Shanna, another defense counselor. So we'll see if the high-profile Jose Baez does in fact show up. Wesley John Holmes joining us from Tokyo this evening, and we got Australia in the house. I see already. You see a bailiff there. Ireland is here as well. I love these early lives because we see the rest of the world, Jeremy. But what was interesting prior to this is that we saw Shanna Gardner and her husband, her new husband, Mario Fernandez Saldana, appear jointly, but that's not going to be the case today. Does it seem like these cases are? It was unclear if they were going to be severed or not, but it appears that they're going to be completely two separate cases here, right?
That's what it's looking like, and I think there's would be a really complex trial if they had to try them together, and certainly conflict of interest between the two. So it's looking to me like it's heading to two separate trials.
And Mish brings up a good point. She already left Florida and was arrested in Washington State. So that's not going to help her case with bond either. The fact that she's already left the state of Florida. Is that right?
That would be a concern. I don't really think the evidence shows that she fled there, but they did have to extradite her back. And I think a judge looking at this would, again, look at the ties to the local community as such, that she has family out there. If you're in Washington, if you're in Seattle, that's just one flight away to another country. And I think that would give the court some pause. But I don't know that there's really any evidence to say that she fled.
Okay. So just to recap, this couple, Shanna Gardner and Mario Fernandez Saldana, were arrested for allegedly arranging the murder of this Microsoft executive, her ex-husband, Jared Bridegan. Last time, like I said, they appeared in court together. They are both charged with murder and each facing potential death sentences if convicted of murder and conspiracy in Jared Bridegan's death. They were previously married and shared custody of two children, and this is where it's so much like the Markel Adelsons here, Jeremy. It was a very bitter custody battle, fighting over the children. Jared Bridegan had since been remarried with two new children, but it was the fight over the older children that appears to be the motive for this murder. But we see it again, and we see it not far from Tallahassee, just across the top of the state there. Another murder for hire. It's crazy.
Well, it is, and the financial aspect of it as well is a part of it. Even with the wealth that is had by the mother in this case, I think there are still issues where she wanted Mr. Bridegan to pay for different things, and he was wanting to try to make it fair, where each side would pay for things, and each side would get half the home. And I think the financial part of it, just like in Markel, that was also an aggravating, an irritant to her. But I think it's one of the reasons these cases are so compelling, because it's frightening. We all know people that have nasty divorces, but somehow people manage to stay within the lines of right and wrong. They don't hire hitman, but this one here, obviously, it went across that line. And it's like, otherwise, ordinarily normal people why would they cross that line and commit murder? And I think it's a combination of factors, child custody, money, your sense of arrogance and entitlement, and would lead an otherwise normal person across that line.
The whole world is here, meaning in the chat. And by the way, you're not going to get this on other channels where you've got a lawyer like Jeremy giving you analysis in real time of what's going on in court. And you're not going to get this either. So we've got the best, I would say, best guest, better community. Laura Waldy gifting 5 Surviving the Survivor memberships. We've got North Georgia in the house, and then you've got Romania. This is why I love these early lives. people from all over the place are here. True Lifestyles is saying that Mario Saldana Fernandez's attorney is there and looking very stressed out, which isn't surprising because his client has his back against the wall. The other interesting piece of this case, I believe those are the Bridegan's, I believe.
That's Mr. Bridegan's second wife, Kirsten.
Okay, yeah, that's what I thought. In court, and I know that True Lifestyle, Susan Harmon is in touch with them. But Jeremy, what's interesting about this is Henry Tenen is the admitted trigger man in this. The guy who was at one point the husband's tenant. His name is Henry Tenen. He pleaded guilty to pulling the trigger that night and has agreed to testify at least against Mario Fernandez Saldana. How big a deal is that?
I think it's monumental. And I think even despite the fact that you have somebody that pulled the trigger and did a despicable thing, he will have a lot of credibility with the jury. I mean, you look at multiple cases where that's the case, like the Chillingworth case, the murder of the judge in 1955 in Palm County. You had really bad people testify, but they were believable. And I expect that would be the same here. That will, I think, probably cement this case in the minds of the jury that actually hears the case against Ms. Gardner and Mr. Fernandez.
Look at this. Big thanks to McSpunky for gifting 16 memberships this morning. I love it. And then we've got Cornwall in the UK here. Cornish Lass. I love that. Jeremy, this is just so similar because you've got in the Adelson case, you've got Luis Rivera who pleaded guilty. He cut a deal and then testified. And this is exactly what we're seeing here. In your opinion, how are these cases just on a broad basis? How are they similar, but how are they different too?
Well, very similar in the sense that it touches on that child custody issue that anybody with children, anybody who's been through a divorce can relate to that. I think there's a dynamic of young, attractive people with a lot of wealth. I think that brings an interest to it. Same as with Markel. I think the fact that you have hitmen being hired and just sort of that arrogance to think, well, I'm going to solve the problem because I can afford to do this. I know nefarious people that can do this. So that part is similar. Mr. Fernandez apparently had those kind of contacts. Where it's different is just the speed at which this thing unraveled, and the state not only went after the lower level people that pulled the trigger physically, the state has gone quickly and speedily without delay against the people who really pulled the trigger in this case, which is Ms. Gardner and Mr. Fernandez. They're the ones that really pulled the trigger. They built the gun and they pulled that trigger back in this case. So hats off to the state attorney's office and local law enforcement that really worked hard, that went right for the people who are ultimately responsible. You know, in Tallahassee, I think a lot of interest in Markel happened because it seemed like the ones that actually physically did the crime were held accountable, but the ones that actually set it in motion and were responsible for it happening sort of eluded justice for a long time. And, you know, a lot of people speculate about why that happened, and that's, I think, part of the interest in it. So hats off to the local authorities in this case that weren't deterred from going forward. And we see today that they've charged and they're going forward seeking the death penalty even. So I think in some ways that gives people a little bit of more, maybe it increases respect for the court system, because the state's not being deterred by wealth or any other consideration. In this case, they're seeking the death penalty against people who would seek to hire hitmen and gun down a father with a 2-year-old child in the backseat of the vehicle right here in the community in Jacksonville.
What's noticeable is the big person in the room is missing. That is Judge London Kite, who's presiding over this case, but and the bailiff is just on the telephone there. So Yeah, I know in Tallahassee with Judge Stephen Everett and Charlie Adelson, everything went right on time. Here, we're about 5 minutes late. One of the issues that came up last time is that Saldana, because it was a joint hearing, one right after the other, but Saldana was in prison garb, Jeremy, but Shanna Gardner was in street clothes. Someone said that Jose Baez, that's a big deal for him. He always makes sure that his client is in regular clothes. Do you think that we see Shanna Gardner in regular clothing today, or does the judge say no? She's got to be in her jail jumpsuit.
The judge could certainly say no because there's not a jury present. An individual doesn't have a right to dictate their appearance when they're transported for a hearing. But it's within the discretion of the court, and I could certainly understand why, if I'm representing somebody and if I'm a high-level attorney like that, I'm going to go the extra mile because it's publicity. This case is not going to be tried in a vacuum in his mind. This is also tried in the court of public opinion, and so that's part of her image. So if I'm in his shoes, I would certainly like to not have her appear just in jail garb, like Donald Adelson or Charlie Adelson are brought in jail garb. They're not looking their best, and that's part of the image you want to put out there leading up to a trial. But the court certainly has the discretion to say no. And the same is true as like when they're in shackles and so forth. They can't be brought into the courtroom in shackles. It would prejudice their right to a fair trial. To show this person they're in jail garb, they're shackled up, it kind of makes the jury think, well, is this person really, really dangerous? So we don't do that in a trial. But there's no jury here. So, the court doesn't have to give them that kind of leeway.
Got it. That's interesting. Annie K here. Is there any progress in getting the defendants to turn on one another? The broader question is, Jeremy, do you think that there's an effort for one attorney's client to try to get the other client or their client to turn on the other client? You think that we're going to see one of them flip here?
I mean, that's certainly a possibility. If you're an attorney, you may try to advocate that to your client. The client may say no to that. If there's still feelings of love and affection between the husband and wife, the client may veto that. But if you're an attorney, you may want to explore that. In this case, I don't know that the state would at all be interested in that. One of the advantages that this prosecution has over Markel is by charging all of the people at the onset of the case, they flip the right person. So they're not messing around trying the shooter and then trying to get one of the spouses to flip on each other. They went after the lower level person. They actually held the gun, and they got him to flip on the ones that paid him and planned. And I think if they had charged everybody in the beginning, they would have got Katie to flip, and they wouldn't have had to have, almost a decade pass where they're trying to get Katie to flip, and they're having to rely on Luis Rivera to testify and all those things. So in this case, I think it's an advantage and a difference that they've done it this way.
And Jeremy, someone's asking what kind of hearing this is. We do know that Shanna Gardner is going to be asking for bond, but it's also a case hearing. There hasn't been a trial date set. She was just arrested in August. I believe the husband, Mario Saldana, was arrested in March, but she was just arrested this past August. What do you think we'll see today besides discussion on this bond? Any chance at all of a trial date being set?
That's certainly possible. They certainly may use this court appearance to take care of that business as well. The judge could certainly just limit it to the bond hearing. Sometimes in Florida, this is called an Arthur hearing. There's a Supreme Court case that talks about the standard at which one may be held in pre-trial detention up to trial. And so oftentimes you call this an Arthur hearing. You'll hear it be called a bond hearing. And those really mean the same thing. But the court may just go ahead and say, do some housekeeping, say, do we need to set a trial date? Do we need to set another case management date or a status conference hearing, depending on what they call it locally? And that way they make efficient use of the time. Each judge is a little different with that. Some judges really want to be efficient. Others are more like, well, we're here for one specific thing. We'll address that, and that's it.
K-Pick and a few others are just tuning in, and they're wondering what this is about. Daily Backup coming to us from Western Australia. Love this channel. Love you back. Someone's asking if Shanna is paying for Mario's lawyer. Not that I'm aware of, but True Lifestyles would know the answer to that. But just to sort of back up here, Shanna Gardner is charged along with her husband, Mario Fernandez Saldana, who she's now estranged from, of conspiring to murder her ex-husband named Jared Bridegan. Her ex-husband was a Microsoft executive. They had 2 children together. He was driving back, I think, from dropping them off, very similar to the Dan Markel case. And there was something blocking the roadway. Here comes Judge London Kite. And
County is now in session. The Honorable London M. Kite presiding. Make sure
there
your
you
cell
go.
phones are turned completely off, and there will be absolutely no talking while court is in session.
Well, we can talk because they can't hear us, but we're going to stop in a minute. So he was murdered, and it turned out a guy named Henry Tennant was arrested. He was a former tenant of the defendant, Mario Saldana, and he admitted to shooting Jared Bridegan, being paid to do that. And now the hitman is going to turn on the husband, Mario Saldana.
Good morning, Your Honor.
This is a different defendant, right, Jeremy? This is not.
We're here for a
He's not
for his violation
part
of
of this
probation.
case that I'm
We are in
aware of.
negotiations
Not-
with the state of Florida.
Yeah,
Asked
so
for additional time to research into the timeline of his case to
there
determine
might be a
if
few
there's
different
any additional
defendants.
credit
Let's
he'd be
just
entitled
take a
to,
quick listen
in
here.
the circumstances of the violation of probation, based on how old it is, and
Yeah.
he sent letters to the court requesting for disposition of the violations of probation. So defense is asking for approximately 2-week pretrial date or pre-hearing date.
Well, that's day-to-day life in the federal or in a circuit court. You deal with a little bit of everything.
But yeah. South Africa's in the house. I just saw. Jeremy, what about the courtroom? This is a beautiful courtroom.
It is, and it used to be the federal courthouse in Jacksonville. Then this
Defense is
The
asking
state
for 2 weeks. Your
took
Honor.
it over. And it's a
someone
very-
made this. Someone made this comment that Shanna has changed. Yeah, she's now a 6'2" African American male. No, that's not her. This is obviously a different defendant, a different case. So they're obviously going through a litany here. Again, this was supposed to start at 9 a.m. One of the things as we await Shanna Gardner's appearance here, and hopefully it will be sooner than later, is it did take a few months. They did have to extradite Shanna Gardner from Washington State back to Florida.
Can we come back on the 22nd?
What is that process like, Jeremy? Did she have to waive her right? Did she have to allow them to extradite her? How did all that play out?
My understanding is that she did ultimately waive extradition, but
Thank you, Your Honor.
short explanation of that is if you're held in another state, you're subject to their territorial jurisdiction, and it's a legacy of the 13 original colonies being original independent states. In order to come before the jurisdiction of another state's court, there's an application the state has to make, and ultimately it goes to a hearing in the state where the person is being held in custody. The governor actually signs paperwork, and if the person waives, that paperwork goes through and they're allowed to be transported to the other state that has the charge. If they fight it, then they have to have a hearing in the state where they're being held to determine if there's probable cause. So it's in many instances people waive and they're brought back, but it still takes some time. If they fight it, then there has to be those hearings, and the governor has to issue a warrant, and they're transported back.
Or March 4th, Your Honor.
And here's another defendant who's in a wheelchair. Speaking of shackles, shackled up. He's in a medical wheelchair. You can see the MED on the back. So we're seeing some other defendants. He's already done. He was in and out in record time. Mish Cavernos, great time for the triple Qs for Jeremy Mutz, who knows a lot about how the courts work in North Florida. She wants to know, and from South Africa, Cape Town, how does spousal privilege work if they are legally still married? What happens there?
Well, in Florida, it's a little different. We don't have the traditional spousal privilege in other states, and traditionally, one spouse could not be forced to testify against another. And you see that like in the Agatha Christie book, Witness for the Prosecution, where that's an issue. In Florida, there's just a privilege that deals with communications with the expectation of confidentiality. So if I talk to my spouse expecting confidentiality about that particular subject, there can be a privilege, but it's not as broad as the traditional, prohibition of compelling a spouse to testify against the other spouse that exists in other jurisdictions. So it may still be an issue in this case, but probably not a very significant one.
Queen Olive here with a personal note. Shanna was arrested in the next town over from me in Washington State, 10 to 15 minutes away. She was arrested in West Richland. I live in Richland, and West Richland is an affluent area because I think her house was $1 million plus home in Washington. Megan says, happened a mile from my house, vested in this witch. There's the photos. There's Jared Bridegan, Shanna on the right, and then Shanna bottom left with her attorney, Jose Baez, and COE. Let me know what's going on. Did we just lose that video? I think it's still there. Just putting up some photos here. Trying to figure out what. Go ahead, Jeremy.
It's an interesting little window into what happens in court, because on TV and movies, we think there's maybe one big case and that's all the court deals with. But here's, people who violated probation, other routine matters that are being taken care of. And, it's kind of a little bit of a peek behind the curtain for people.
Yeah. And I do see the courtroom. We'll go back to it in a minute. I'm not sure what COE is up to, but I know she's put some photos up. Megan says, happened a mile from my house. There you go. That's crazy. And there you see Shanna Gardner with Mario Fernandez Saldana. That's her new husband. She met him reportedly at a CrossFit gym. Shanna Gardner is a physically very imposing and fit woman. You can see she's substantially taller than her husband there. Big, strong woman. There's video of her arrest, body cam video of her arrest, and she just kind of walks out. She's not overly fazed by it. One of the things that happened here too, we're back to video of the court. Let's keep that up, guys, just so I can keep an eye on it here. But that's another defendant with
available the week of February 20th.
That week we have. Could we have Thursday the 22nd, Your Honor?
Yes.
And would it be possible to waive our client's appearance at that date?
Yes. Okay. February 22nd, 9 a.m. pre-trial.
Thank you, Your Honor.
Thank you.
And that's all I have. May I be excused?
Yes.
Thank you, Judge.
Jeremy, it's interesting because everyone knows that everyone here is tuning in for Shanna Gardner. Is there a reason that they're kind of holding off on her a little bit?
Well, I think the court may just want to get through some of the shorter matters first. Different judges would have different thoughts about this. Some may say, let's just take care of the big thing and get the media out of here and get everybody out of here, and let's just get on with normal business. Some judges have the idea, let's take care of the shorter stuff first. And then
Mike Clerk on behalf of Mr. David Markham. He is in jail. I will be waiving his appearance today, Your Honor. He was brought over. However, in speaking with the bailiffs, they were concerned for his medical condition. And so I did ask to have him sent back to the jail. With Mr. Markham, we have received a report. We received a report from Dr. Anderton as to Mr. Markham's competency. I sent that to Ms. Wilkins.
I'm just going to mute this for a second, but this is a different defendant who's not feeling well reportedly and had to stay in jail. So you see the justice system at play here. Pat Vanderwalt coming to us from South Africa. One of the other things, Mario Fernandez Saldana, whose own attorney previously, this looks like Saldana. What's going on here? I didn't think he was appearing today. Let's see if this is him.
Is the state going to speak? It's a nice
Looked like him.
Did, yeah.
Yeah.
I appreciate an answer for that. To make sure I've been in contact with several different departments that's tracking this movement at this point. So I need to consult with them before, based on the fact that it's conditional.
I'm going to see you all back next week, okay?
Yeah, that's him.
Yeah. I don't think we were expecting him. I did not know that he'd be here today, but that is him. This is Shanna Gardner's husband. I believe he's still her husband.
Yep.
And you said you sent the report this morning.
Yes, Your Honor. It was sent to Ms. Wilk, I believe, like 8:50.
Okay, thank you.
Thank you.
Morning, Your Honor.
Good morning.
Christina Stifler for the state. We address the cases of Mario Fernandez Saldana, number 9, Shanna Gardner, number 11 on the court's calendar.
This is Mario Fernandez Saldana, the husband, shackled wrist and feet.
Good morning, Your Honor. My name is Jesse Dreiser. I represent Mr. Fernandez along with my law partner, Mr. Hill, who is present.
Good morning, Your Honor. Patrick Cody for Ms. Gardner, and Mr. Baez is present on Zoom.
Thank you.
And there's Shanna Gardner together.
Okay, good morning. All right, so I passed this to get a status on the defense position.
Sure.
On the motion that was filed by Mr. Fernandez.
So on Tuesday of next week, we have our first deposition of the Secret Service agent who has coordinated a lot of this discovery that is sort of in dispute. And we have another deposition scheduled. The defense's position, knowing that the court and everyone would like a quick turnaround on this, was to come back the week of the 22nd to tell you that we're ready for you to assign us a neutral, an independent magistrate of some sort. I hesitate to say, well, let's just do it the week of the 22nd, because there, a deposition could be canceled. We may learn that there's more discovery. As the court knows, there are so many issues that come up and may come up. And one we already are experiencing, which is we're having trouble accessing what the Secret Service has sent us, and our expert has been provided it, and he's working on unzipping that file. And we're working as fast as possible to get this to a point where the court can hear it. And
did any depots occur in the month of January? Because I thought you all were going to schedule the depots this entire month, and that's why I brought you back in February.
No, ma'am. The first depot is on Tuesday.
Does the defense seek to depose anyone locally? Was it a 2E issue with getting the federal agents to comply?
We did have to send 2 letters. There's a lot of lawyers. There's a lot of calendaring and schedule issues. The state gave us dates. They were very aggressive on making sure that they gave us time. The defense went through our calendars. I mean, I know that the court would have probably liked the depositions to be concluded, but I don't believe it's a lack of our effort. I can tell you that.
Okay. So on February 13th, you have one Secret Service agent scheduled.
Yeah, and then another agent who is intimately has knowledge of this particular issue is scheduled.
And another agent. I thought you were also going to take depots of the company, this taint.
On next week, on the 13th,
Is two
I
witnesses. I'm sorry.
provided their TB letters, there's no TB issue, these witnesses are absolutely willing to come. Secret Service agent, ATF research analyst, and I have made names and addresses for next point personnel and expert witness available to defense.
When the state says that there's no TUI issue, the court asked, did we have to provide TUI letters?
Right.
And yes, we did. They sent, Ms. Stifler sent us an email saying, you need to provide TUI letters. We had to draft, prepare TUI letters, get them to the state. And I made no indication that they weren't willing to come, but there was steps that had to be taken in order to get them to come.
I understand.
Okay.
I'm just trying to figure out what the process was, and then the next point person, that's also going to be done, or that's a different day?
It's actually someone from the Secret Service and someone from ATF, and they're both on the 13th.
Okay.
We can add, I mean, I've given them no dates, these witnesses are all on standby at any point, they want to schedule a depot, we're willing to do that.
That's good to know.
Next week, so.
And is Ms. Gardner participating in these depositions?
We are, Your Honor.
And through the month of January, we were still being provided documents as to this very issue. And I think the court should know that as well.
Okay. So just bottom line, you think that you would have some type of position the 22nd?
I'm hopeful, yes, ma'am.
Okay. All right, let me talk to you, Mr. Cody and Mr. Bias. Where does it stand with Ms. Gardner?
Your Honor, we're in a similar posture with respect to the motion to disqualify the state. We did file this week a bond motion, which we would like the court to hear. We spoke to the state about dates. We did propose the 27th and 28th of February. The state indicated that that was not agreeable to them. The state indicated they would like to resolve the disqualification issue before any bond motion was heard. Our position is that we need to hear the bond motion, that is separate and distinct from the motion to disqualify the state. And we'd ask the court to set a date for the bond motion so we can be heard on that motion and establish whether or not Ms. Gardner is entitled to a bond. We have now reviewed the majority of the evidence, or what we think we need to review to be in a position to file this motion. We do not believe that the state can meet the very high burden that's required to deny a bond for Ms. Gardner. And so our position again, judges, we would like to have that motion heard.
And so you want the bond motion heard prior to the disqualification. Do you have any authority on that?
Judge,
Has it ever been?
I don't, and I did not know it was going to be an issue until this morning in speaking with the state, frankly, that would be their position. But I can research that if the court wants that researched.
I do.
Yes, Judge.
I think it's important. If you are alleging that the state has information or has done something inappropriate to warrant an extreme remedy to get rid of their entire office, I think that I'm interested to see if that's ever been litigated before.
Yes, Judge, I just make 2 points. The first is that it's not Ms. Gardner's fault that there was this whole next point issue, right? And she's been now held since August. And we had to do our due diligence before filing this motion so that we knew that it would be an appropriate motion to file before the court. So that's the first point. And the second point I would make to the court, that if the court finds that she is entitled to a bond, even with this evidence that they may not have it may not have been right that they had access to, then that bond would still stand and be appropriate. If the court found against us on the bond motion, but then disqualified the state, we would probably, reviewing again the case, find that it would be appropriate for us to refile the motion before a new state attorney and get their position on it, because the bond motion would have been completed with access to evidence they shouldn't have. My point is, Judge, either way, if the motion is heard before the disqualification issue is resolved, there is zero prejudice to the state.
Is there any thought by you that they would try to seek to present evidence that you're claiming that they didn't have access to in that hearing?
Judge, I don't believe,
That's what I'm trying
Yes.
to avoid.
yes, Judge, I don't believe so.
Okay. What's the state's position?
The state's position is that it would greatly prejudice the state of Florida, not necessarily myself or my office, but if they're going to have a bond hearing, the state of Florida is going to respond in kind with a motion for pretrial detention, both under the statute and under the Florida Constitution and State v. Arthur. We're going to attach evidence to our response. We're going to call witnesses. We're going to present evidence to the court to prove her guilt by proof evidence presumption grade. If we do not have a disqualification motion prior to that, and in the event that the court does disqualify the Fourth Judicial Circuit from the case after denying bond, they can renew that motion with the state of Florida and another prosecutor's office, which would then have to relitigate the issue, which is a burden on the state of Florida. It's a waste of judicial resources, and it greatly prejudices the state. My position is, and my position has been, the state of Florida has not accessed or has not used, read, or otherwise plans to use any information which is privileged. That's our position. That's what the hearing on disqualification is for. I believe we'll be successful in the disqualification motion, but I do believe that it would be greatly prejudicial to the state of Florida and the prosecution, whether it's our circuit or another, to have this bond hearing in the event that they can argue substantial change in circumstance and relitigate an entire bond motion in the future. I'm asking this court to set the hearing of disqualification in February after defense has done their depositions, after we've had the independent administrator review a document that Mr. Fernandez's counsel and I dispute is privileged. There is no such dispute as to Ms. Gardner. Their motion is limited to the state of Florida potentially had access at some point to privileged communications which were never viewed or reviewed by anyone in law enforcement or the state. I want to have that hearing before this bond motion. Also, the state's going to file a written response. I'd like to do that sometime next week, give them notice as to what evidence we're going to present, what witnesses we're going to call. I'm not asking for a great delay. I think on the track that we're on, given any unforeseen delays, with the state of Florida having provided all this information to defense, assisted them with their subpoena ducas tecums and their 2 letters, making these witnesses available, I'm hopeful we can have this hearing on disqualification late February, early March. I would ask to set the bond hearing mid or end of March. Ms. Gardner has been in custody since September. She did not waive extradition, so she was held longer in the state of Washington until she got here. She's entitled to her hearing on their motion. I agree with that, but I don't think she's prejudiced in any way in a delay of 1 month. They filed a motion this week. The state of Florida should have the opportunity to file motions in response and prepare for the hearing. The state of Florida also should not be prejudiced by having a disqualification motion hanging over our heads with statements by counsel that if the court denies bond, they're going to refile it and grant the disqualification motion. I think it makes the most sense too.
I thought you all told me when speaking to Mr. Crody and Mr. Bias that you all were reserving the right to amend the motion of disqualification based on any discovery that you all were conducting in the interim. Last time I saw y'all, we were in December, we're now in February. You indicated that whatever the cloud, what's it called?
Next point.
Next point. This was shut down for you all. You all were going to conduct the discovery and you were going to amend potentially the motion that you were adopting based on what Mr. Fernandez, am I understanding that correctly?
Judge, that is correct. We are still struggling, as is Mr. Fernandez's defense, in opening the information that we received from the Secret Service. So that's one hurdle that we're facing. The second thing is that we need those depositions completed to see how we're going to proceed with regard to this issue.
Okay. Well, to me, just practically speaking, to avoid any, if you all, in a hearing like this, not necessarily that they have to put on everything, they have to put on a substantial amount to meet the burden that you alleged in your motion. It's practically speaking, to avoid any discovery violations, they're saying you didn't have it. They obviously can access it. You're saying you're having trouble with it. I'm just gonna,
Just one clarification, what they're talking about, I do not have access to. That's the whole point of the state's position. They received the unredacted versions of the phone downloads. The state of Florida does not have possession of any of these. They got them directly from Secret Service. So I just want to be clear about that. Mr. Drexler, I had this communication with him this morning about that myself.
so you don't have access to what they're
No,
saying
ma'am.
that.
That's
Okay.
the whole point. They wanted it from the
As-
original P agent. The state of Florida does not have access to these documents or files. I can't provide them to them or system in any way.
To be very clear, they have had access to the very documents and emails and the things that we've alleged in our motion. Let's not be confused about that. What they don't have access to is the unredacted raw data that the Secret Service went through before the Secret Service turned over all of our privileged emails to the state of Florida, which were uploaded to NextPoint. So
Well, that's in dispute.
that's not in dispute. That there is no
Well, I'm
dispute.
not gonna argue that.
Well, it's not. I mean, the emails that I sent my client sent me were uploaded to NextPoint by the state of Florida. That there's no dispute. Whether they looked at them or intend on using them may be in dispute, but there is absolutely no dispute as to them being in possession of them. So, it's a machinery issue. This particular data the Secret Service uses, the agent told us you have to have special software, forensic software, to open it. So we hired an expert who we believe has that. He's working on doing that. And hopefully we can have that done by Tuesday. If not, we may just, at the expense of what I'm told this software costs, we may just have to ask the questions, what did you have, and see if we can do it that way. That's why there's some uncertainty as to how prepared we'll be come late February. But I think through good.
Why not exercise 3.220 where you can have them open it up?
And review it. And during the deposition, we
No, I mean prior to, so that you know what questions you can ask on record.
I
You
think,
can inspect outside of the deposition.
sure. If we were talking about inspecting photographs that a medical examiner had taken or something like that, that tool is readily used and available and useful. I suspect we're talking about thousands or hundreds of thousands of documents and images. So the practicality of doing something like that, hey, maybe we just go to your office and sit down with you. It just, in this particular case, I don't know that that's a feasible tool to use.
All right. This is what I'd like to do. I'm going to bring you all back.
I'm sorry, we do have one other issue separate than that. So Mr. Fernandez on December 13th filed a motion to compel contact visitation. We're having some difficulty with our mitigation specialist, Dr. Brooke Butler. She's gone to the jail. We sent over a letter saying she can go to the jail. That worked once, then it didn't work. Then they said that the letter was dated the day before. Then the next time they said she couldn't have contact.
You mean in those rooms, just they're open?
Yeah.
Not through the glass?
Without us being there. I mean, the expense of having a lawyer sit there, she's sometimes there for an entire day or two at a time. So we're asking, and it's never been an issue. I wasn't there the first time we introduced Mr. Fernandez, and then we left her to do her job. So we're asking the court to issue an order just allowing
I have to give
the city
the
council.
general counsel notice.
Right. So if we could,
So what I was gonna do, why don't we handle that? I'll bring you back on the 14th. You all let me know how the deposition went. After the 13th, we'll handle, I can give notice to the general counsel related to that issue. Maybe it won't be an issue and they'll just allow it. But I do know that they have,
stand.
I can't issue an order, okay? They'll just file a motion and,
I've run into that before, so I've addressed
so
that.
I need to get what Ms. Young's position would be on behalf of JSO. I've had one other issue like that and we just were able to resolve it, talking it through.
Okay.
And there's some type of list. Has you gotten on that?
Yes, ma'am. I think we've done everything we can from our side.
Okay.
So now the plan is to come back on the
I
14th.
don't see that motion you're referring to. Oh, no, I see it. Okay, so I'm about to run on it. All right, we'll have a conversation about that, and you'll let me know how the depositions go. Then hopefully we can schedule a hearing, and if you all would be prepared, both sides, if this has been litigated before, where there's a pending disqualification motion and also a bond motion that the defense wants to hear. I don't want to resolve it necessarily practically, but there is some guidance out there, I like it. So if you would do some research on that, okay? And I'll send you all back. Are you all available on the 14th?
Yes, ma'am.
I am not, Your Honor. I currently have a trial scheduled on that day.
You do, okay.
But,
What about the next day? I'm sorry.
I can speak with Ms. Gardner and see if she's fine with Mr. Karobi appearing on my behalf.
And I'm available on the 14th, Judge.
You are.
Yes.
It's just, Mr. Bias, if you're not available and Ms. Gardner agrees, if you would just communicate your schedule, it would just be, I wouldn't be having any type of substantive hearing. It would just be to schedule the hearing. I'm not doing anything other than getting an update on the discovery. I do need a position on Ms. Gardner about whether you intend to amend or if you're going to go with what you have, if you believe that you need additional discovery in order to adopt what Mr. Fernandez has filed, so that we're all on notice of what the issues are, okay?
And Judge, I do believe we adopted their motion. We just indicated that we may supplement it.
That's what I need.
Yes, Judge.
I need to know, from your perspective what the information is, what your objections are, so that we all, when we have a hearing, it's a full hearing and, decisions can be made. And the state's put on notice about what Ms. Gardner, I believe that they're sufficiently on notice based on the pleadings in Mr. Fernandez's case. I'm not exactly sure. Ms. Stifler is indicating, the position that you all laid out initially. I don't know if that is the full breadth and scope of your objection. Does that make sense?
I think it makes perfect sense, Judge, and I think it's certainly not our intent to sandbag the state in at any hearing. So absolutely, I think it's important for them to know the issues as well as the court ahead of time. So that's something we will do happily.
Do you think there are any depots beyond the ones on the 13th?
There may be.
Okay. Well, I'll get your position. I'm going to tentatively set up, the way that we're set up right now, I don't think you can have that conversation with Ms. Gardner about whether Mr. Crady, would you like to speak with her? Just briefly, I'll set it on the 14th if you're.
Yes, Judge. Was able to speak with Ms. Gardner quickly, and she is okay with waiving Mr. Bias's presence at the next court date.
Okay, so that's just going to be scheduling. I'm going to get an update, okay? February 14th, 9 a.m. for pretrial on both cases, okay? See you all then.
Yes, ma'am.
Thank you, Your Honor. Can I be excused?
Yes, thank you.
And there they go. Shanna Gardner leaving in street clothes. Legs were shackled though.
Members of the Bridegan family are present for today's court date.
Thank you for that.
Judge London Kite was just mentioning the Bridegan family who is there. That's the Bridegan family. There's True Lifestyles, our very own Susan Harmon. and I'm just going to mute. Mario Fernandez Saldana is there. Jeremy, why is he still there? Do we know? Oh, there he goes. He's leaving. They were just waiting for someone to escort him out.
Right.
So that is the hearing there. Bunch of stuff to go over, and Jeremy's got some limited time, so we'll go through this quickly. I just took some notes. So I was not expecting this. They were appearing together. He was in a green jumpsuit, Mario Fernandez Saldana. She was in a blue shirt and black pants. Once again, Jose Baez, who was not there but was on speaker, he wins that part of this little competition, right, Jeremy? I mean, there's no jury there, like you said, but still the optics for the media are that one's a criminal, the other's in street clothes, isn't it?
Right. She'll be on the local news tonight in street clothes. She'll be on court TV and the B-roll type footage, and she looks a little bit better. Not a significant win, but it is a little piece. And again, if you're that attorney, if you're trying to play at that level of being a top tier attorney, that's kind of the extra mile that you'll go through to do that. And there's also a subtle idea there of showing a distance between your client and this really bad guy who's in jail clothes sitting there. And they may be trying to create some daylight there. I said before, I thought husband and wife, probably unlikely that they turn on each other. However, if you delve into the background of the relationship, Miss Gardner said she only married Mr. Fernandez Soldano because he kind of pressured her. I'm going to be involved in your kids' lives, so we should get married. So how much affection does she have for him? Those are all things that I guess we'll see over the next few months.
Yeah, and from what I understand, they are separated now. I mean, figuratively and literally, they are separated, and they probably will not be together for the foreseeable future. But the big question that everybody had here, one of the issues was the deposition of a Secret Service agent. Why would the Secret Service be involved in this? Is this in order to basically get into the forensic data related to the case, Jeremy? Why are they involved?
That's part of it in terms of just collecting the evidence, but they also served as sort of the protector of confidential material. So the Secret Service actually served as somebody independent from the state attorney's office and other law enforcement, because some of the evidence that was being collected in this case would be wiretap evidence, would be evidence potentially that would implicate the attorney-client privilege between Ms. Gardner, her lawyers, and Mr. Fernandez Soldano and his attorneys. So if you gather evidence like that could be subject to privilege later, and the court will have to make a decision on whether it's usable, you can't just spread that information through the prosecution unit, and because it would create a taint. So if I gather this information, I have to keep it separate. I can't let my prosecutors look at it, because that's why they've moved to disqualify the entire state attorney's office in Duval County off this case, because they say this information wasn't contained. You let the prosecution team and other people look at it. You can't unring the bell. You can't unsee something. So if the court deems this is not something the state should have and should not use, according to this theory of the motion that the defense has filed, the entire prosecutors can't be involved. It's kind of like in Markel, if everybody remembers, the use immunity that Wendy has in testifying. There's a big issue there whether they could ever charge Wendy, because how do you separate what was learned in that testimony from the other evidence that's not tainted and affected and influenced by that evidence? That's why it's a little bit tricky, and it's tricky in this case. Other similarities with Markel. In Markel, the defense at one point moved to disqualify Georgia Kappelman, if people remember that. And it was a similar type issue. And just the sheer volume of evidence is similar. At one point, Georgia said she had 8 CDs of discovery to turn over to the defense. In this case, it's probably going to be more. And that's part of the challenge in the modern day. In the past, a murder for hire plot, maybe you have a note or a letter, or you have phone records. Now you have thousands of emails and text messages and different apps that, you need a teenager almost to tell you what apps are out there to keep up with them. That the parents are, the kids know more about what's out there than we do. But all of that evidence, you get thousands and thousands of communications, and sort of the dragnet of all of that they brought in this case. Some of it may be admissible, some may not, and that's what's at issue with this. I tend to think it's unlikely that the entire state attorney's office is going to be disqualified, but it's a tricky issue. They have to show that this evidence wasn't just, put out on one drive and everybody could look at it.
True Lifestyles letting us know that she just talked to Kristen Bridegan, the wife of Jared Bridegan, who was tragically murdered. And she told her that she hopes justice keeps moving. She just left, and they're not really allowed to speak about the case, but we will get her on the show once this trial concludes or when she's able to speak. Yeah, Jeremy, that's a huge ask. I mean, the defense is basically asking for the entire state's team to be dismissed from this case. Is that just more gamesmanship at this point than anything else?
I think so. I think so. Unless they could really show something was disseminated within the office that got out for consumption beyond the immediate prosecution team on this case. But it's a tricky subject matter. When you're talking about emails between an attorney and a client, that's really heavy stuff. I mean, that's stuff that you can get bar complaints. You can get really in a lot of trouble with that. And it's something that you really have to tread lightly on and be very careful with. But it sounds to me like the overall effort to prosecute these individuals, they assigned a taint team, which was the Secret Service, to try to make sure that this was dealt with properly. So I think they'll be able to show it was properly maintained and they handled it carefully. From what I understand, they created an entire sort of a containment system, a database, if you will, to put all this information in. And it took months for them to put this together. So I don't think they just put it on hard drives or just, put it on some computer in the state attorney's office. And I think they did what they were supposed to do.
Yeah, and the defense, I think, was saying that there could be hundreds of thousands of documents or 100,000 documents at the very least. So
Sure.
He said that their office is trying to work on that. Jeremy, forgive me if I didn't understand this, but what happened with the whole issue of bond? Was that even covered, or is that going to be covered at the next hearing?
It's going to be covered in a subsequent hearing. And part of it was if the state attorneys are disqualified, you don't want to have to do the bond motion twice. If they go ahead with the bond motion and then the state attorney's office is disqualified, and that was kind of the point the prosecutor made, then they'll bring this motion back again. We'll be doing it twice. So they're going to wait on a ruling on the disqualification, it seems.
And then Jose Baez, who's reportedly getting paid something like $500,000 a month for this case, which is quite the retainer. Jeremy Mutz. He wasn't even in court, but we heard him on speakerphone. What's he doing today that's more important than the $500,000 a month he's getting paid, Jeremy?
He may have another hearing or something going on. It's hard to say. When I practiced in Daytona Beach, people didn't even want to pay $850 for a divorce. So, $500,000 a month is a pretty sporty fee. I think if I were getting a third of that, I'd probably want to be there, but maybe he has another court appearance he can't get out of.
Yeah. And True Lifestyles, once again, local news is waiting outside. Yeah, First Coast News and Action News Jacksonville. I love these names. They're straight out of straight out of a movie. But it goes to the point, Jeremy, this is going to be all over the local news. And again, people are going to see the newly estranged husband with his hair pulled back in that green prison or jail jumpsuit. And they're going to see Shanna Gardner in street clothes. How does that influence a potential future jury?
Well, it certainly can in subtle ways. And it may be intentional to subtly put distance between the innocent, attractive young woman versus this fellow that she described as a pit bull. Watch out for him when you're interrogating him. He's a pit bull, things like that. And there's sometimes that factor, regardless, that people can be sympathetic toward an attractive woman on trial and may have more sympathy for her. And that might be something that it seems a little craven, but her defense can exploit that and have her put her best foot forward and make the best appearance possible in the public. Because in a case like this, you're not only tried by the jury, you're sort of tried by public opinion. And there's all kind of little unspoken mentalities that people have about women committing crimes. I mean, I worked for a state attorney, an elected state attorney, that didn't really believe women could commit crimes that were serious crimes, and almost put women on such a pedestal. Of course, in reality, unfortunately, the human nature is what it is. Men and women both can plot horrendous things. But there are some people that will be more sympathetic to women, put women up on a pedestal. And in some ways, that's sort of a gentlemanly idea. But in terms of a case like this, then it leads a juror to not look at just the evidence, but they're being influenced by feelings of sympathy and, some of the baggage that we all bring to the table in evaluating somebody. And they can certainly exploit that. And I mean, if I were defending her, I'd want her to dress a certain way in front of the jury, and I'd want her to come across a certain way in front of the jury. And I think that's, pretty normal.
By the way, if you're loving Jeremy, he's coming back tomorrow, 5 p.m. Eastern. We're going to discuss Donna Adelson, who she is returning to court next week. And Jeremy will be our premier guest on our panel tomorrow, 5 p.m. Eastern. Again, Donna Adelson and Dan Rashbaum head back to court. And we haven't gotten Jeremy's reaction to my interview with Dan Rashbaum nor Donna's arrest yet. So we'll get that tomorrow night. The final thing here, and then we've got to let Jeremy go. They set another court date now, it appears like, ironically, on Valentine's Day, February 14th. Again, Jose Baez came in on speakerphone. Judge London Kite told the defense that I need your position on Shanna Gardner. She was saying that to Jose Baez. But what can we expect now on Valentine's Day 2014, which is, believe it or not, next week?
I think that's when they're going to argue this disqualification motion. And so we probably still won't have an issue. We probably still won't have a decision on the bond motion then.
And if you had to guess, how far off do you think a trial is the way things are going right now?
It's a good chance it may not even be this year. And I think so just the amount of documents that you alluded to, the amount of communications that we're still kind of not even to kickoff at this point. We're still arguing about whether the state can go forward on this case, whether they have to be removed because they've seen something that they shouldn't have seen in that big collection of communications. And this is where it could go beyond just wiretap evidence and attorney-client privilege. It could, in fact, touch on the spousal privilege in this case if it's emails and texts between Ms. Gardner and Mr. Fernandez Soldano. So that is interesting that almost rarely used provision in Florida of the spousal communication privilege would actually probably play a role in this case. From what I see in the motion for disqualification, that part of it is based on communications between the two spouses.
Emily Weinzap saying that Jose Baez has already stated he's not going to be ready until 2025. If I was him, I wouldn't be ready until 2029 if I'm getting paid $500,000 a month. So he's holding off. And then got this here. Congrats to Millie Miles. You won the giveaway from the Best Trials channel. We do have another channel, and starting literally in 1 minute, we are going to be covering the Michelle Troconis trial out of Stamford, Connecticut. She is on trial for conspiring to kill Jennifer Farber-Dulos. We've been covering that gavel to gavel. Huge thanks goes out to Jeremy Mutz, who now has to go to his day job, which is lawyering. So, Jeremy, look forward to seeing you tomorrow, 5 p.m. Eastern, on Donna Adelson and Dan Rashbaum. And then thank you for joining us.
Well, you're very welcome. Thank you for having me, and certainly some fascinating cases going on right now.
100%. Love you, America. Love you, North Florida.